Hello, everybody, and welcome back to 62 Who Knew. This is our 45th show. In 7 weeks will be our 1-year anniversary, and we have something incredible planned for that. But I have 7 weeks to plan that, so that'll be really great. But it is going to be a great show, and I want to welcome you for being here. I'm sorry about last week's repeat. That was my own personal fault for not being able to get here on time. But we did show one of our more popular episodes with Mr. Mark Goldberg, our favorite long-term care insurance expert in the country, and Ms. Diane Daniels, the founder of the Medicare Nation. And it seems that long-term care insurance and Medicare seem to be the tickle spot of our audience, because that's when we have our biggest shows. So even as a repeat, we had a little more than 40,000 viewers. So thank you for being there for that. Tonight we have a very special guest. He was with us on the 4th week, 41 weeks ago. Mr. Joe Pippen. He'll be introduced in a little while. Has built one of the most prestigious law practices, not just in Florida, but the southeastern United States. Has the longest running attorney call-in show, and has helped more than 50,000 people in the last 35 years. That's really a staggering number when you think about it. So as always, I'm going to start with just a quick synopsis. I'm going to welcome back Nada, because she hasn't been here for a few weeks between helping her mom and being sick. Welcome back, the co-hostess with the mostest. You don't see her yet, but that is her hand. And yes, there she is. And there is Mr. Pippen. So for a second, before we go right into the show, as we always do, we're going to do a quick synopsis of what is 62 Who Knew. And we're always so happy to do this, because it seems like the premise of the show has certainly caught on, as we started 45 weeks ago with no viewers. And now we're up to more than 40,000 a week, with a goal of 100,000 before the end of this year. That between our brilliant guests, like the man we have tonight, and the power of WeBeam TV and John Gaston and many other things, we're going to meet that 100,000 goal before the end of this year. But what is the premise of 62 Who Knew? It's a simple premise, and people seem to have accepted it. As you approach the age of 62, and you approach that age of retirement, and 62 seems to be the magic number for retirement. Maybe it's because that's the year you can choose to take Social Security. Maybe because that's mandatory retirement in many large corporations. But for whatever reason, whether it's my generation, I just turned 61 on July 4th. None of you sent a card, but that's okay. No, nothing personal. I'm not taking it personally. Whether it's my generation, which is the baby boomer generation, or our fathers or their fathers before them, or even their fathers, everybody has the same thoughts as they approach retirement. Should I take Social Security? Should I defer to a later age? Did I save enough money? Should I invest in the stock market or income annuities? Should I have long-term care insurance? If I already have it, do I have enough of it? If I don't have it, am I too old and too unhealthy to get it? The questions are unlimited, but all of us ask the same questions, except for maybe the top 0.25% of the country, the people with a net worth of 20 million or more. They don't ask those questions. The rest of us all ask those questions. But my generation, the baby boomer generation, has a different obstacle, a different hurdle to jump than any preceding generation. And what is that? Longer lifespans. Modern technology, scientific, and medical breakthroughs over the last 30 years are allowing us to live longer than ever in the history of our world. In fact, if you make it to 62 today, you have a 50-50 chance in this country of making it to 90 or above. And when you let that sink in, the ability to live 62 years, then want to start planning your retirement, and knowing that you're going to be here half the time that you've already been here. So we get right back to that statistic that only 0.25% of this country is capable of retiring in the early 60s. The rest of us are trying to figure out how to do it. And that is what this show is about. Who knew at 62 that you would get this far in life and go, wow, I still have 30 more years. How are we going to do it with a quality of life? So that's the premise of our show, and we endeavor as much as we can to bring guests to you every week to help that quality of life between 62 and when you ultimately leave us. So thank you for accepting our premise. We are back, and without further ado, for the second time, Mr. Joe Pippen.
Hey, it's great to be here.
It's great. You were the first person, we tried a call-in show. And you were nice enough to tutor me and say how difficult that really is, because you've been doing it for decades.
We did get some calls that night.
We did, and I was, you were happy. At the end of the show, I went, only like 3 calls, 4 calls, what happened? I was on your show, and the phone never rang. And, of course, you gently... What?
Always rang.
Yeah, always. It never stopped when I was there. It just never stopped. But you've gently and politely reminded me that you've been doing it 35 years, and I've been doing it 4 weeks. Well, that was our 5th week. So we went away from the call-in segment, and we went back to this type of segment, and we've been growing ever since. So things have changed since the last time you were here. Not too much, but enough. And we always start with the same question. It doesn't make a difference whether our guest is an attorney, a long-term care specialist, an annuity specialist, health, travel. I always ask the same question. What got you specifically 35 years ago, not just into your radio show, but into law and into elder care law specifically? I have found that most of the time it's a personal thing that has to do with parents or a relative or something like that. So that's my first question before we go technical on you.
All right, well, first of all, I've been practicing law for 38 years, and then I've been doing my radio show for 35. So I didn't start doing my radio show until about 3 years into my practice. I think I always like to tell the story that when I finished college, my dad says to me, we know you want to go to law school. Mom and I would be glad to help you like we did through college. But if you get married, you're on your own.
Oh, wow.
That's what I was told. And I've been dating my dream girl for 5 years.
Oh, wow.
And so I wanted to get married. So we got married, and I went to night law school. So I had a good job up in Baltimore, going to law school at the University of Baltimore at night. And I actually stayed with the company for 11 years. Then I got a job offer down here in Florida to be general manager of a small electronics company. And at age 35, I had my law degree, and I had never used it. So I told myself, if I don't use my law degree now, I never will.
That's true.
So I ran for the Florida State House in 1982 and started my law practice at the same time, left the job. And I tried everything my first 2 years. I mean, I did bankruptcies, I did foreclosures, I did divorces. And somebody that had known me along the way in my business path invited me to come speak at a seminar on estate planning, financial planner. And then I got some business from there. And I decided that I didn't want to do trial work, didn't want to fight with people. I wanted to help as many people as I possibly could. And estate planning seemed the perfect way to do that.
Absolutely.
Because I can just sit in my office all day, have clients come and go, and I did something they're happy with. They put it off for a long time. They finally got around to it.
Yeah.
And I was able to help give them peace of mind and really do something great to help people in my practice.
And this does. I mean, the peace of mind that it does give a person, you don't really think about that till you're older.
Right.
And knowing things that are taken care of for your children and your grandchildren once you depart this earth.
So when I was, after the campaign that I didn't win, didn't miss it by much though, I had met the editor of a small local newspaper. And I said, you know what I'd really like to do is to write a column called Ask an Attorney. And it would be a column where people would send in their legal questions. So the first few weeks I made up questions, but then it caught on and people started sending questions. And after about a year and having about 50 articles, I published a little book. Took the book by the local radio station, said I'd be glad, here's a book that I just wrote, and I'd be glad to be interviewed if any of your hosts would like a guest. The manager of the radio station, they immediately had me on one of the shows. Phones lit up like crazy. Manager of the radio said, we would like to give you a show. Would you please come in and do a show called Ask an Attorney? And it didn't cost me anything, which is unheard of today.
Absolutely.
That's amazing.
And so then I had a 3-hour show on Sundays from 1 to 4. Phones filled up the whole 3 hours. And then I was on radio and television and all kinds of things happening. My book kept growing, and I have like 13 editions of the book, Ask an Attorney.
What is the name of the book? Oh, the book is Ask an Attorney.
So that's the story.
That's a great story. I got to ask, high school sweetheart, still married?
49 years, it'd be 50 this December.
Oh, that is incredible. Congratulations.
That's awesome.
50 years. That's 7 times both my marriages. That's a feat.
Now, 2 days ago...
The same woman?
Yes.
That's incredible.
2 days ago, I hosted my parents, who are still married and living, I should say.
Yeah.
75 years.
Wow.
God bless them. That's incredible.
And they both got married when they were 20, so they're both 95, been married now 75 years.
Are they any chance they're watching?
No.
You came on this huge TV show, you didn't tell them?
Well, I don't think they have watched TV on their computers.
Okay. Oh, that's right. That's John's fault. Why aren't we on ABC? Okay. Yeah. Well, you'll send them a link.
I will.
Well, and give them my absolute best. I think that is so incredible.
That's amazing.
Yeah, my generation and little younger generations do not take the, I joke about it, but I wish I was married 40, 50 years or something like that. It just didn't work out that way. But I think that is incredible. And I met your lovely wife just a few weeks ago when we saw each other at the restaurant. Yeah. And that's just incredible. I really think that's great. All right, you're going to ask some questions. Nada's going to ask some questions because she hasn't been here in a while, so we're going to get her back in the flow. And Nada, you go ahead and take over. I'm just going to be the pretty.
You're going to take over. You're going to sit there and look pretty?
Yeah, I'm going to be the pretty one today, and Nada's taking over.
All right, so you do a lot of estate planning.
I do.
So what is who are the people that should do estate planning?
Well, I think everyone should do estate planning. If you have assets and want to plan on what to do with them, you should. And anyone over the age of 18 might have a car, might have assets. At some point, pretty soon after 18, they might have minor children. So it's very important to have an estate plan of who the guardian who would raise the children, when the money gets distributed out, and so forth. So if you don't have a will, guess what? You have one anyway. You have a statutory will. So the state of Florida makes a will for you, and all states have statutory wills. So if you don't do one, then you've said basically, here, I don't care how this is distributed, who gets it, who's in charge of it. You haven't made a plan, so the state makes a plan for you.
And that's probate.
That's probate,
Or is that
but
part
there's
of
a
probate?
statutory distribution of who gets the assets, who's going to be the guardian of the minor child, and who's going to be in charge of your estate.
Okay.
But I have to ask, if they do this statutory will and there's two children, logically what, they give half to one child, half to the other?
Yes.
Does Florida dip their hand in for anything?
Well, no. Is there a spouse involved?
Okay.
Are there other children from other marriages when you die? I mean,
gets kinda complicated.
Well, it could. But if there was one marriage and two children and the second spouse dies, statutory would go to the two children on a statutory probate, which most of my clients like to avoid that probate.
Absolutely.
So.
Is there a cost to do probate too?
Oh yeah, the attorney fee is 3 to 6%.
Oh wow. Okay, so
Very,
that's
very expensive.
So you're better off doing some pre-planning with an estate plan.
Oh, absolutely.
Okay.
Plan to avoid probate.
So 3 to 6%. So you're talking about, let's say, Upper America that's dying with $5 million in their estate. They're paying $150,000 to $300,000.
Well, there's a sliding scale downward
on
the fee. So after you get past $1 million, it drops a little bit, and it continues to drop a little bit. But there's still but the attorney can charge whatever the client agrees to.
Right.
So if the client doesn't know any better and they come in and say, well, that'll be 3% on the $5 million, and the client agrees to it and signs a fee agreement, then it's 3%.
Right.
If they shop around a little bit and find someone else that charges according to the fee schedule and the statutes, it'd be less. And if they negotiate real hard, it could be even less than that.
Than less, yes.
So who is the person usually doing that? Since the person that left it is dead, is it usually, since there is no will, who's doing it?
Well, an interested party, like the two children,
Yeah.
Okay.
would come in.
Or maybe another attorney.
Well,
He's not talking about hiring the attorney, though.
No, say maybe one of the children could possibly have
Right.
not somebody on,
Okay.
a
yeah,
retainer.
one of the children could come in, or they could both come in. And if they both agree on who would be the personal representative, they can agree to that, and one would be appointed. If they both want to serve, then they would both could be appointed as co.
Okay. But you have to use an attorney along the way, though, when you're doing that.
There are 3 levels of probate, and if you're under $6,000, you can do a possible way to do it was without disposition, they call it, without an attorney. From $6,000 to $75,000 is called summary. If there's more than one beneficiary, you need an attorney there. And over $75,000 is called formal administration, and you need an attorney.
Okay. All right. So what are the different ways to avoid probate then?
Well, most of my clients, this little poster sheet that you mentioned earlier, I'd be glad to send this to anyone that would be interested in it. And it's got the 3 options in estate planning. It's got a cost of probate chart with a little comparison between wills and trust. On the other side has the website information, the attorneys and offices and so forth. All right, so what was the question?
How do you avoid probate?
How do you avoid probate? Most of my clients choose option number 3, which is a living trust.
Okay.
So a living trust is just a fancy will. You create it when you're living, and when you die, the trust is still living. So that means the successor trustee that's been nominated now takes over, and because the assets are not in the name of a deceased person, like with a will, they're inside a living trust, the successor trustee can immediately take over
Okay.
those assets, pay the bills, do the creditors, do the taxes, and make the distribution. No probate. Very
Okay.
quickly and privately. If you have a will, the will becomes a public record. There's a probate fee. You didn't plan for guardianship or incapacity, which is very important. With a trust, you do, and it's a private document. So a will's a public record. Trust is a private document.
Okay. So that means, like, if you did do the will, you could have people coming out of the woodwork laying claims on the deceased person's stuff.
Oh yeah, lots of people say that they were a child and feel like they're entitled to something, or they come up with an old handwritten will, or a lot of different things can happen unless you have a formal will prepared.
I don't know why anybody
properly.
would in today's world. I mean, other than being destitute possibly, but I mean, you would want to have this. It's not an expensive thing, especially if your net worth is probably, like, let's face it, 90% of Americans, their net worth is 90% of their house. They're not leaving much of else. It's a sad statement, but that happens to be true about us right now in the condition we are. How could you not want a will or a trust to say where your only asset is going?
Yeah, and see, if you have a house, like a lot of our listeners have a home, do you want that to go through a probate process when you die?
I would think not.
Because it's going to be in a deceased person's name unless you do some planning. One of the big mistakes, though, people will say, well, why don't I just put one of my children's name on the property or the car or the home, unless I'll just give it to them joint with right of survivorship, and when I die, it's automatically theirs. Well, if you do that with a home, guess what? You've messed up the cost basis upon death. The whole property is not going to get a stepped-up cost basis. You've possibly lost some of your homestead exemption, and you find out later that could cause you back taxes and problems like that.
But what do you mean by that?
Yeah, expand on that.
Can you explain that?
So many people are
Because-
confused by that.
Yeah, I'm confused by that.
By putting someone's name on a child's name on a house?
Oh, putting the child's name on the house. What if they did? Because I know that there's something called a life estate
Ladybird deed.
Ladybird.
Is that the same thing, life estate deed?
Well,
Yeah.
it's different than joint ownership by putting someone's name on it. But a life
Right,
estate
right.
and Ladybird deed are the same thing, basically.
Okay.
So there's nothing wrong with that, and that does avoid probate.
Okay.
The difference I like to explain is if you have a living trust and put the home in a living trust and become incapacitated, then the successor trustee can manage that, make decisions about it, sell it, do whatever is necessary, because now they're in control of the real estate for the benefit of the person who created the trust. If you did a Ladybird deed, just like a transfer on death or a paid on death account, nothing happens until death.
Okay.
So you don't
could pose a lot
have
of
the
problems if
flexibility
you're
of
in a
being able
nursing
to
home
take
or
over the property when you're living.
Okay. And then the other thing I was going to ask, and then so back up to when you said you can lose some of your homestead stuff. If you put the name on the deed while they're living, then back up to what you said that you could lose some homestead rights.
Okay, well, first of all, that would be a gift, and you can only give away $15,000 per person. So if you're going to put someone's name on the deed to your house, the house should be appraised, and then you're going to have to fill out a gift tax return to report that you've given away more than $15,000. You can elect not to pay a tax and use up part of your $11.4 million exemption upon death. You can use part of that if you make a gift while you're living. The problem, though, is when you live in their home and you're entitled to the whole homestead exemption and you put someone else's name on there, not only is there a possible gift problem, but now you don't own the whole house. So you're only going to be entitled to half of the exemption. So you messed up your homestead exemption, and you messed up, if you die with a house, then it gets a stepped up cost basis, which means now that house can be sold at the full value of the house. If you give it away, then only half of it gets stepped up.
It also could affect their interest write-offs, because even in today's world, although with the new tax laws, most people are not using the interest anymore because there's such such a huge deduction, an automatic deduction. But if half the person owns your house doesn't live there, you really can't write off all of your interest on your owner-occupied mortgage. Probably only write off half. I'm guessing at that.
So why do you think a person would want to put their child's name on their house?
To avoid probate,
Avoid
probably.
probate, yeah. But see, they don't think about all these other problems.
Right.
They don't think about the appraising, the gift tax, the loss of homestead. And the homestead has a lot of asset protection value. Nobody can sue you and take your homestead. But you give away half of your house to your son or daughter, and they get sued.
What if they live with them?
If they live with them, then they both could be entitled to the homestead.
Yeah.
Okay.
But if they get sued and they don't live there, then half of it's not homestead, then a creditor can possibly...
Subject to creditors.
Yeah, subject to creditors, the half they don't own.
You mentioned $15,000 per person for a gift. Is there any scale on that, or depending on your net worth, or that's just it? That's the regulation.
Per year.
15 grand.
Per person per year.
All right, per person per year. And there's no gift tax as long as you're 15,000 or below.
Right. Well, actually, there's no gift tax. You could give away 100,000.
Mm-hmm.
You fill out a 709 gift tax return, and you say, I've given away, you don't have to report the 15, so I'm reporting $85,000 gift, and elect not to pay a tax on that and use up your lifetime exemption. So now your lifetime exemption dropped from 11.4 minus 85,000.
So really, the great majority of the country could actually do that if they wanted to, because how many people really, are having a $22.8 million estate, or 11.4 if it's only one of them? I don't know that percentage, but it's got to be ridiculously small.
But on the other hand, there's no reason to give away money if you're not going to have to pay tax on it for the most part.
That's right.
It used to be to give away money to reduce the size of the taxable estate.
Yeah.
Or give part of it to charities that would be taxable. There had a lot of good reasons in the past to give money away. Now you really don't have many good reasons, tax-wise and so forth, to give it away, unless you just want to be helpful to your family.
It would be nice just to do it to be helpful, but yeah,
right.
No tax benefits. Sorry, we never liked you that much, and there's no tax benefits. So, sorry, Junior. Paying off your student loans.
Right.
Yeah. Wait till I die.
And you don't have to give them anything when you die either. That's another kind of myth, that they would be entitled to something. Children aren't entitled to inheritance.
Mm-hmm. That's true.
So you don't have to give them anything if you don't want to. In fact, if you didn't want to give it to them, I have a client every now and then that comes in and says, well, I've got 2 wonderful children and 1 child I haven't seen for 30 years, and I don't get birthday cards, I don't get phone calls, I don't get anything. They've disowned the family, and I don't want to leave them anything.
Looks like the milkman. I mean, it's just
So then what I do is I just put in the document, I've omitted so and so for personal reasons, because you don't want them to make a claim that they just forgot me.
Yeah.
That's not a real good legal argument, but they could cause a lot of trouble to. So you just put, I've omitted so and so for personal reasons.
And you could just put down a charity, and as you said, leave out the children. And if it's done correctly, the children really have no right to contest that, I guess, as long as your client was of sound mind, I would assume.
Right. Yeah, the most reasons that are used to contest documents like wills and trusts are incompetence or undue influence. Now, I have an undue influence case all the time. I had one today.
Undue influence. Explain that to us.
Okay, so what happened was elderly mother came in with daughter, and elderly mother, and I says, before you say anything, I want to tell you that if you have come here with your daughter and she's going to be favored in the document, don't speak any more about it, because I'm not going to do the document. I said the biggest reason that wills get contested are undue influence. So if your daughter drove you here, sitting here, is listening to our conversation, and you do a will or trust that leave everything to her, it could easily be contested by your son, and he would win most of the time. Because they're going to get daughter in a deposition. Did you bring mother to the meeting? Did you drive her? Did you call and make the appointment? Were you sitting in the attorney's office? They asked you 50 questions to make you look bad, and you lose. So then it goes back to 50-50. So I said, Mother, if you want this to work, you need to come back on your own. Your daughter was going to New York tomorrow anyway. I said, don't tell her about the appointment. Come in on your own. I can do the document. I'll write in my notes that you came alone, and the document most likely is going to work.
I never would think of anything like that. That's incredible.
That's interesting.
Yeah.
That's really interesting.
So that's what she did. They both left. She wasn't going to tell her daughter when she was coming back. All she had to do is call in my office and make her own appointment.
Right.
And she'll come back, and I'll do a document, and it'll work. Otherwise, it could have easily failed.
Right. It's almost like an appeal.
Yeah.
Yeah,
Wow.
that's very interesting. I never would have thought that.
Yeah, you think most of the time incompetence would be the reason that most documents would fail. It's undue influence.
Undue influence. I think back on, I took my dad to every legal appointment and every doctor's appointment and every appointment, in the last pretty much 5 to 8 years of his life. So, wow.
Well, part of that's not fair in my mind.
Right.
Because, daughter, it doesn't matter whether it's daughter or son, but
Right.
I'm going to use daughter, quits her job up north, comes down to take care of mother, takes her everywhere, takes her to doctor's appointments, does everything in the world for her.
Yeah, why should the other people get as much as her?
Yeah, but if she came and brought mother to my office and I did the document and the son that's never contacts anybody, doesn't really care that much about the family, contest, he's going to get half.
Yeah.
So it doesn't seem fair that this daughter who does everything for mother, takes her everywhere, shops for her, does everything you can imagine.
Quit her job.
Quit her
Move.
job, moved,
Yeah.
gave up her life.
Yeah.
And now she's bringing mother to the attorney's office to do a document, and mother wants to leave her more or everything. And I've seen it all. I've seen it a lot. It gets contested, and they say, "What's undue
It's
influence?"
mean, I'm sure.
Wow.
It doesn't seem fair, but that's what happens. That's life.
That is life.
And then what is the difference between transfer on death and paid on death?
Well, you can go to your bank, most likely, and you can tell the banker that you want to set up an account. And they either call it transfer on death or paid on death, so you can set up account mother, paid on death to daughter. Mm-hmm. So the question is, will that avoid probate? The answer is yes. Is that the best way to set up an account? Well, maybe not, because most of us, we don't like to think about it, but most of us are going to become incapacitated at some period of time before death. And if that money was in a trust, then it could be used by the trustee, which could be the daughter, for the mother's benefit as long as she lives in a lifestyle she's accustomed, and still avoid probate upon death.
Okay.
And not only that, if mother also had a home, that could be put in the trust to avoid probate. So a living trust is far better in my mind than a paid on death or a transfer on death account. Now, some accounts that people own are like life insurance, annuities, retirement accounts.
Mm-hmm.
The asset itself is structured most of the time to have a beneficiary,
Right.
like retirement accounts, insurance.
Right.
So the question is, do those go into a trust? In most clients, the answer would be no, because your goal was to avoid probate, and the product itself avoids probate because it's structured that way. But there are some circumstances where the beneficiary would be a trust. Now, the examples I like to give, if you have a spendthrift child, would you give them an inheritance to be gone very quickly? And you want to make sure that your hard-earned, long-earned money is going to last a while, then you can have it come into the trust, and then you can stretch out the distribution over time.
I like that.
Yeah.
Suppose you have a child with an addiction. You give them money outright, what have you done? You just enabled the addiction. Mm-hmm. So I have a case in Jacksonville where a man last year was in hospice, had 2 sons. He had wonderful son A, who had a good job, hard worker, good spouse, good family, attentive to dad, cards, birthday, lunches, and all kinds of things. His other son lived under a bridge and had addiction problems most of his life. So dad says, I love them both. I want to treat them equally. So he gave, we'll call wonderful son, his 50% outright. In fact, he already has it because I'm the trustee. Mm-hmm. And the other son has to go, he gets a monthly amount, and of that, rent gets paid directly to the landlord.
Very smart.
Most of his expenses and doctors and medical appointments are paid directly to the doctors. In fact, the dad said, get him some front teeth. He lost his teeth. I want him to have some nice-looking teeth so maybe he can get a job, straighten out his act. And he gets every 2 weeks he gets a food allowance. What he does with that is hard to control.
Right.
I make him go to AA meetings. I make him report to me. I give him my cell number and say, you call me if you have an urge to drink. And I have the ability to suspend his distribution if he has a problem.
Seems like you're going above and beyond as more of a quasi-replacement father than an attorney.
Well, yeah, but a good trustee would do that in this case.
No, I think that's incredible.
The parent trusted me to do that, so I'm
Congratulations.
doing my job.
I mean, that's a wonderful thing to do.
So also, now I have a special needs brother. If my father gave me half of the estate and my special needs of a brother half of the estate outright, he'd lose all of his government benefits.
Of course.
So
Wow.
there's a
I didn't even think
special
about that.
there's a special needs trust. You can have half of it go to my brother, but only can be used to the extent it doesn't interfere with any government benefits he's entitled to. So there are a lot of wonderful things you can do in estate planning
Yeah, I know.
for
Well,
a
I know.
really good result.
I know in my other world, in the reverse mortgage world, the proceeds of a reverse mortgage will not affect Medicare or Social Security, but can have a devastating effect on Medicaid or other government entitlement programs, unless we use a professional like yourself to set up a trust so they can access those reverse mortgage proceeds for exactly what they need to be, but not past the threshold of income or assets at the end of every month. Yeah, it's.
My brother was on private. My dad was the president of an insurance company, and he was spending like 25% of his salary at one point taking care of my brother, trying to find him help.
Mm-hmm.
And my brother was in a private place over in DeLand, Florida, and the owner and my dad became friends, and the man eventually sold his business, and he said, I'm going to try to get your son in a place in Gainesville. And this is a wonderful place with like 300 acres of land. They have cottages of 12 residents with around-the-clock care. Now, if my brother had gotten 50% of his inheritance,
Mm-hmm.
he would have lost that. He would have had to leave the facility.
Right.
This facility is not accepting new patients. So he could have burned through all of his money, which would have been very quick because he's, his high need with
Right.
special care. And then he couldn't have gotten back into the facility just because of a mistake in the estate plan.
Mm-hmm. Mistakes in the estate plan can really be generational.
Oh, absolutely.
Going forward.
Absolutely. So I know we kind of covered the gifting rule, but is there anything you want to add to the gifting rule? Like, how do those work? And
Well, you can just write a check for $15,000 per person, but there's a lot of confusion about gifting and Medicaid. Because people hear us talk about the $15,000 per person rule that you can give. The IRS doesn't tax you. But if an elderly person were to give $15,000 to their children, there's a 5-year look-back period on disqualification for Medicaid planning. So
to stop
it's different.
somebody from liquidating all their assets so they qualify for Medicaid.
Right, or giving them all away.
Mm-hmm.
You give away, you have a $500,000 estate, you give away $500,000 so you don't have any assets, so you qualify for Medicaid. You fill out the 709 gift tax return and report the gift. But guess what? You've disqualified yourself for Medicaid. There's a 5-year look-back period. They look back for gifting.
mm-hmm.
So we don't use gifting at all in Medicaid planning, and we discourage people from making gifts if you're close to going into a nursing home,
Right.
because you could be disqualified. So we have a full-time Medicaid attorney on staff, and basically what he would do is to shift assets into non-countable categories. Your homestead doesn't count up to $560,000 worth of value, doesn't count as an asset at all. So sometimes the person might buy a more expensive home, use their cash that would disqualify them, buy a more expensive home. You can put money into a personal service contract.
What is that?
All right, that's a care contract for life.
Mm-hmm.
So elderly parent puts, they have a home in $200,000. So we put the $200,000 into a personal service contract to usually who their power of attorney person is. And the power of attorney now can use that money for their care, but it doesn't count as a gift to them because it's in a special
Okay.
needs agreement, personal service contract. So there are lots of ways where people, even with money, can qualify for Medicaid almost right away with some of these special rules that most people don't know about.
The 5-year look back, is that only gifts, or what if you start liquidating stock? If you own a piece of a privately held business that suddenly gets signed over to a relative, is the 5-year look back just gifts or all assets?
Well, all assets that are gifted, which
Okay.
could be stock.
Yeah, I think gift, I think writing a check, but
Yeah.
it actually could be stock.
Well, no, but the trick there would be to get evaluation that was low by a professional.
Right.
And usually the more owners you have, the more diminished the value is. If you have multiple owners on like a limited partnership,
Yeah.
for example, you can get it appraised a little lower.
Mm-hmm. Makes sense.
So,
Yeah.
so there are all kinds of ways to do things that people should know about.
Okay. Let's see what else we got here. How do you avoid guardianship court with legal documents? How to
That's a
avoid
biggie for
guardianship.
us too in the reverse mortgage world.
Yeah. Well, guardianship, if I was speaking to an audience, I'd say, how many of you would like to be declared incompetent and the court appoints your guardian for you? You know, nobody would raise their hand. But hey, if you don't plan for it, it's possible. You could have a stroke or an accident or become incapacitated. The best way to avoid guardianship is to give someone a durable power of attorney, give someone a healthcare surrogate, and of course assets in a trust can be used for their benefit as well. But those are the important documents. And if you have those, just think guardianship's a very expensive process to go through. I mean, you're talking about $5,000 or $10,000 probably the first year in fees. No, it's not quick. If you've given someone the power of attorney to act on your behalf, they have an immediate document, well, now it's a 14-page document in their office, but they have the power to do anything you could do. So you don't need to be declared incompetent. You've legally given someone the power of attorney to act on your behalf. Same with the healthcare surrogate document. You've given someone the power to make all your healthcare decisions when you can't. So there's a few little simple documents like that. They cost like $125. You're avoiding thousands of dollars in legal expenses. And anyone could have a stroke or an accident today or tomorrow.
Yep.
Yeah, you don't plan for that. It's not on your schedule.
I know. So if you got a document to cover yourself, then you wouldn't be declared incompetent because you plan not to.
Yeah, I've only had a couple in my 12 or 13 years of doing reverse mortgages where the family really needed this, but they hadn't done a durable power of attorney while mom and dad, or either one or both, were mentally capable. It was too late now.
Yeah, they can't
So now
sign
you
a
have to
document
go
now.
through the guardianship, but really and truly the purpose for the reverse mortgage, whether it be a new roof or medical, was immediate. But it took 3 to 4 months to get a judge in Florida to sign off on the guardianship. It was just sad. Very sad.
No, you got to send out 2 doctors to do an evaluation. You got to have a hearing with notice. You know,
Holy mackerel.
all kind of things have to happen before you can have the person declared incompetent. And then they have to basically decide what rights they have still, and what, you know, if they've lost all their rights, or there are a few that they can. Can they still get married? You know,
It's very
that's
well, yeah, you have to be fairly insane to get married to begin with, but that's just a poison point of view for me. I can't believe that. John just said 8 minutes. I would have guessed that
A half an hour.
at most that we were talking. That's amazing. Oh my God, I lost my train of thought. What were they? You were talking.
We're talking about
Oh,
durable power of attorney and
that was a
everything.
the guardianship.
It's 17 minutes. It wasn't
Oh.
8 minutes. He was saying something else. The guardianship. Yeah, I also noticed in one of the cases, and people don't think about this till it's happening. I'm sure you guys see it all the time. It's very emotional to actively try and have your mom and or dad or anyone that you love legally
Declared
declared
incompetent.
There's a certain emotion there. You know you're doing it for the right reason. Yeah, but this is the person that taught you how to play catch, taught you what 2 and 2 was, taught you how to drive your car,
On
and
the
now
other
you got to
hand,
do this.
On the other hand, sometimes they're very stubborn about doing a document too. You can say, Mom or Dad, you need to do a power of attorney. I need to have power to help you. I want to be able to make healthcare decisions. If you faint and fall down and hit your head, nobody has the power to do anything for you. So sometimes they don't want to do the document.
I know.
And sometimes they just won't do the document, so then you're stuck with a guardianship.
Yeah. There's so many things in your world that people don't want to do. They need to do it. In fact, they probably need to do it earlier than they do it.
Yeah, well, one of the key things is at what point does a parent take the car keys
That's
away
right.
from mom or dad who no longer...
We've talked about that
Yeah,
with
we've
all our
talked about
long-term.
that,
That's
yeah.
the psychological part of taking the keys from your mom or dad is very rough.
My dad still talks about getting the keys. He's got dementia.
Well,
He's always asking me where his car is.
I've had, you don't have to be, you could just be weak, too weak to drive, but you're mentally fine. You don't have reflexes enough to slam on brakes if something happens in your car. You don't have reflexes to swerve quick enough or do lots of things. So it doesn't have to be mental. And I've had people who come into me and they ask, the child will come in and say, how do I get the car away from, my parents? They just won't listen to me. So I said, well, look, what I would do is just call your parents' doctor. Have the doctor do it. The doctor knows they shouldn't be driving.
That's right.
and they might not. They need a little push sometimes, and it's not you. Don't take the hit yourself.
Yeah.
Keep your relationship with your parent and have the doctor revoke their license.
Everybody takes that type of news, I think, better from a stranger. I remember when I said to my dad, you really shouldn't be driving anymore, and I can't repeat what he said to me. We were very close, obviously, and we lived with each other, and then about 15, 20 minutes later, I've told the story before, he went, you know what, I know you're right, but don't sell it, and leave the keys where I always put it. I'm not going to drive, but I'd like to again one day, so let's not sell it. And I went, okay. And that made him feel better.
Right.
But the first reaction was, X-rated. I can't say it.
I mean, I couldn't imagine
Very sad.
losing my right to drive.
And I don't mean that this is easier for a woman. Please don't anybody write in and say I'm being a chauvinist. But a man and a car are very different. Even if you're not a car guy, a man and his car are bonded from the time they had their first car when they were 16, or the time they took their father's car or mother's car for the first time. It's rough on a man.
I'm pretty bonded to my car.
Your new one, yeah.
Well, I just like being able to drive.
The sad thing is a lot of the older folks don't like their cell phone and don't want to use and learn how to use a cell phone, because there's Uber. Now you can have your groceries delivered. You can have restaurant food delivered. It's just as easy as punch a few things in on your cell phone and there you go.
Yeah.
And life could be almost the same in today's world with all the technology that's available to them. But
I'm also noticing not just older people. This used to be, I think, especially for older people, but not anymore. In certain beautiful communities around, you're seeing people do everything on golf carts. Street legal golf carts in their community.
They can be dangerous
not
too,
just
though.
to go to the golf course, though. They're taking it to Publix. They're taking it to
they
the
have
local
special
restaurant.
parking spots. What
a world.
Sun City Center, where I have one of my offices, they have the biggest golf cart parade every year. I mean, they line them up and they shut down the streets, and there are thousands of golf carts going down the street.
Yeah, I've seen them that look like Hummers, Corvettes,
Yeah,
Mercedes.
they look really nice. They're really nice.
They got to be a few bucks there.
Oh, they are.
Are they?
They are. Oh, yeah, they can be pretty pricey.
What a community.
For sure.
Yeah.
But they are fun. But I do know somebody who got brain damage from one, that a car hit them when they were crossing.
Yeah, it's got to be, that's dangerous.
It's still dangerous. Still dangerous.
Well, that can happen with anything, though.
Right.
Motorcycles, scooters.
Right.
Yeah.
There's still a degree.
So one of the questions I get once in a while is a couple will have a joint trust and they get divorced. So the question is, what happens now?
That's right, yeah.
So basically the answer there is you take all the assets out of the trust because they're going to split them up anyway, and then you create your own trust. And another question I get all the time is, suppose I have multiple pieces of real estate. How do you get those in a trust? Because they could be located in different states. One beautiful thing about a trust is you can put it, it's the bucket, I call it. So you can put real estate in it from all 50 states if you wanted to.
Really?
And avoid probate in all 50 states.
So our trust law is mostly national, not state?
Yeah, but I would always get it the attorney in another state.
I got to sign off on it or something. Okay,
yeah.
I got you.
So timeshares can go in trust to avoid probate. You have a lot of things that you don't think about are going to go through probate, but they do.
Mm-hmm. Now, when I came onto your show, because I know we're not short on time, but we're getting towards the end. When I was on your show, there were some incredible questions, but there was some that, I had to back away from the microphone because I laughed. So I got to ask you this, because there was one, we're not going to talk about this one, but there was one that I just went like that, and you shut off the microphone and went, oh, I get this all the time. What is some of your more laughable questions? Because we got a couple on the hour that you invited me.
Well, excuse me, one lady wanted to know if she could probate her own will. Of course, you have to die first. And after about the third time of explaining to her why she couldn't, I think she might have finally gotten it. Mm-hmm. One man called and he was talking real slower than this. I mean, it was just like a drooling question, and I'm just sitting there trying to be patient to let him finish his short question that was taking forever. So he finally said, I said, what's determined the problem was that the funeral home director had kept the gold from his mother's teeth. Or wouldn't give him the gold from his mother's teeth.
That's real sensitive.
Gosh.
On some
this was
real
years
deep
ago.
issues.
Well, this was
on real deep levels.
Yeah, well, this was a long time ago, though. This was probably the first 3 or 4 years I was doing the radio. So I said, well, and I kind of just chuckled slightly while I was stalling really to try to think of how I'm going to answer this question.
Yeah.
And then the guy, in his really slow way of talking, said, you're going to laugh at me like everyone else has. But he said that super slow. So then I had to spend time assuring him I wasn't laughing at him. I was just kind of pausing, thinking of how I was going to help him and answer his question. So I know I get...
That's terrible.
Yeah. I've got some gold teeth from one of my estates in a little sealed bag, trying to figure out what I'm going to do with them, because I guess I'll get them appraised somehow. Because gold's worth a lot now. Back when this was, the gold wasn't that valuable.
I never even thought about that. So
I really?
Yeah. So,
I guess sometimes the funeral homes must just look, and if it's gold in their teeth, they might pull them and give them a bag to the family. I don't know.
Is there a law about that? That, you know, if it was in the deceased, it belongs to the family?
Well, yeah.
I never thought about that. You know, there's, you know, of course now we don't use gold, but even when I was a kid, gold fillings were a thing, and it was bigger than that before I was, you know, born. Yeah, you know, at a what's gold up to now? How much an ounce?
It's over.
I have no idea.
Yeah, it's a lot. I don't know exactly.
We have 40,000 people watching. I'd say 20,000 are going, Grandma, open your mouth for a second. Because I see a new boat in my future. Grandma, say, that's incredible. I never would have thought of that.
Well, some of the other questions was a lady wanted to know if she and her dog could be cremated together.
Well, I hope the dog
Well, if
is
the dog
alive.
going to be dead.
Is she going to kill the dog if she's going out?
Well, no, she wants the dog to die shortly after she does, and they want.
Okay, that's
she wants to
rude.
be
That's wrong. I hope you said no to
cremated
that.
Oh my gosh.
Yeah, I want that
is
dog.
kind
I
of
want that
bizarre.
dog taken away. Do we know where that woman lives?
I had people ask if they could be buried in their backyard, you know, things like that. I've got a lot of interesting questions. I should write a little book about the most
I was
interesting
just going to say
questions.
that. You should write a book about the most, because that would sell. It would keep people smiling.
It would be.
Yeah, without
That'd be
getting
very
too much
funny.
into detail, we had a question about a man that was injured on his privates. And I thought maybe you were setting this up to get me to laugh.
Oh.
Because when the guy started talking, because he was getting some very serious questions about estate law. I mean the phones just don't stop on his show. And then this guy calls up and starts to talk about the injury to Mr. Happy, and I thought he was just setting me up so I would be hysterical. And I'm like this, I'm pushing the button so you can't hear me, and he pushes his button and goes, "No, this happens."
Oh my gosh.
I never set up a call. I mean, I just don't need to.
I thought you were just trying to make me laugh.
Yeah.
That's funny.
Anyway, can I?
No,
Promote
please.
this one
No,
more
I
time?
want you to promote yourself,
So-
your website.
All right, so we have 20 office locations around Florida. This is our poster sheet, I call it, a estate planning poster sheet. It's got 5 articles on the front side about wills, trust, probate, little charts to explain everything. On the other side of the sheet is my website, office locations, attorneys, radio shows. Radio show is every Saturday morning on 570, 910, 860 in this area. And you can contact me. We have a toll-free office number, 1-800-226-3529. You can email me at Joe, Joe, at ATTYPIP.com. And I really want to thank you for having me on the show again.
Oh, no, I hope you're going to come back. And I do. You've seen this on my desk.
Yeah.
It was 9 months ago when he was on, 10 months ago. And it has made me, obviously, I never pretend to know more than I want, but I also don't like looking dumb. And referencing this has allowed me to go,
Yeah,
look,
that
you
is
need to
nice.
call an attorney.
I want one of those.
Because, well, if you call in, you'll get a free one.
I will. I'll be the
And
first
I
one.
want to say that Mike's my go-to guy on any reverse mortgage questions. Sometimes I get reverse mortgage questions on the show, and I'll call him. I forget what the last one was. A little bit unusual because
Yeah, but we
a wife
Yeah.
who only had a life interest in the trust
Yep.
got a reverse mortgage. I don't know. That's going to be a lawsuit
Yeah, there's no doubt about that.
because she
No
took
doubt
money
about
when
it.
she couldn't.
But we
shouldn't have.
actually helped. I think I got about 8 calls in 15 minutes, and some of them, of course, a lot of times people already have a reverse mortgage, and unfortunately their lender is not answering their questions. So I was able to help some people. But no, I closed a very nice reverse mortgage, and when I say very nice, it wasn't large, but we really helped the person, which is always a great feeling. Yeah, in fact, anytime I got to sit down and talk to you about maybe doing something on your station, for reverse mortgages, because again, part of longer lifespans, there are 3 things that people just need, and it's amazing to me. I shouldn't say that. Your industry, they need. They must prepare for death with certain things. I wasn't the only person that heard that too. Okay, good. I'm glad you both looked up because I don't want. But this whole show. And not just this show, much bigger mainstream shows than us are all about funding longevity. how do you get from the early 60s to 90, 95? And we've had a guest twice, the regional director from the Weizmann Institute in Israel. We're 10 to 20 years away from things coming out pharmaceutically that's going to take us to 100, 110 years old. So funding longevity is on the tip of every elder law attorney, certified financial planner, long-term care insurance agent's person, mouth. And no two things do that better than long-term care insurance and reverse mortgages. And when structured correctly with a professional like you, most of America can have a great life from 62 to 90, 95, and sleep it well, knowing that they're passing on wealth, with the lowest cost possible. So I want to talk to your radio station about possibly maybe doing something consistently about reverse mortgages, because I thought, again, if we got 2-3 calls in that 15 minutes, and I know you usually don't.
You
have
want to get
guests.
the show right before me or right after me?
Whatever gets me. Well, I would have to say, I don't know. Whatever gets me to take advantage of your 35. I want to just hook my
Probably
caboose
right
on-
after my show.
I want to hook my caboose right up to your locomotive there and just keep just keep going. You know what I mean? I want to be the Jay Leno to your Johnny Carson. That's my thing.
All right. Sounds like a plan.
Let's talk to the radio.
All right.
It's a great little radio station too. Do you still have the same producer? It was a young man that was super cool.
Lahudi.
Yeah, he's a super cool guy. John, about how much time do we have? 4 minutes. Well, really and truly, thank you as always. I hope you're not a stranger. We are going to be, the audience knows, changing to a panel show. 2 to 3 people at a time, bringing in the most popular people of elder law attorneys, long-term care insurance, reverse mortgages, Medicare supplemental policies. This seems to be what is allowing 62 who knew, to grow, to where it has. So I hope you'll consider coming back. I know you got to drive to be here. You can always beam in, but we love having you right here. Yeah.
Yeah, I came today from Davenport, so it's like...
How long is that? About an hour and a half?
No, it was like an hour and a half just to have gotten home.
Oh,
so
my God.
It was probably 2.5 hours.
What were you doing in Davenport?
I have an office there.
Today's your day.
Polk
Oh,
County,
okay.
yeah, so.
Well, always know if you're far away, you can beam in.
Beam in and beam me and
it.
Scotty.
That's it. That's
We'll do it.
exactly right. And anything else that you can think of? Anything about
I
maybe
just
with
wanted
your
to
dad?
make a comment, that's
Okay.
all, and just to see if he sees this. My husband's a financial planner, and I also am licensed to do some. But there were several times that we had people come into our office. They had, he would always review their trust.
Mm-hmm.
Several times, the trusts weren't funded with anything. Nothing in the trust.
Yeah. Well, that's why the way I do my practice is I send them a letter every three to 4 years and ask them to come in for review that doesn't cost anything, and that's one of the questions. At my meeting when they're signing the trust, I give them written instructions on how to put their property in the trust, and I always do their Florida real estate for them as part of the package. But we get them to initial little sheet that tells them how to do their checking, savings, money market, CDs, how to get these things into the name of the trust, because all it is adding the word trustees and the date of the trust behind their name, and it's not difficult. But if some people, though, they just don't get around to it, or they close one account and open a new account and don't think about it. There are some people who just need to be reminded every now and then.
That's most people.
I just wanted to make that comment because I've
funding
seen
the
it.
trust is very important, because if you don't...
Otherwise, you don't have a trust.
Well, I've run.
Well,
I mean, you
a
have
trust,
it, but-
then you have a pour-over will. It's going to be probated to get assets from the pour-over will to the trust.
Yeah. I've had many people say to me over the years, not just reverse client customers, "Oh, I went online and I did a trust." I go, "Okay, can you send it? Because the title company and the underwriter have to review it." And they did go online and put in there, but they didn't do anything with it. It's just like this blank thing. I go, "Well, what's in it?" "Well, I went online, I paid the $99 and I did it. It's done." I go, "But there's nothing in it." Yeah, it's really very funny that they don't realize they got to do something.
In a
with
lot
it.
of states, a lot of times they're like a national document. They're unique little things in Florida, like the homestead, they haven't considered. And then they can't do the deed themselves usually correctly into the trust to avoid probate. So,
It's interesting.
Could you give, somebody just text me, could you give your website again of how they could get a hold of you?
the website is www.attypip.com. You can email me directly at Joe, J-O-E, at attypip.com.
All right. We only have about a minute left, and there are actually, not even, The voices in my head just said not even. And we do have a few more questions that I'll forward to you. How much do we have, John? 10 seconds? About 35 seconds. We actually, no fooling around, all fooling around aside, have 3 more wonderful guests coming in July. I have a couple of incredible people in August, one of which is in the top 1% life insurance salespeople in the country.
Wow.
So we have never had a life insurance expert like this that is be coming on, and we'll probably have a long-term care insurance expert at the same time. So with 15 seconds left, thank you again.
My
I hope
pleasure.
you will
It's
come
great to
back.
be here.
Thank you. Glad you're back.
Thank you.
And,
Good to be back.
to the audience, thank you for supporting us. Thank you for growing. Go to 62whoknew.com for information on reverse mortgages, long-term care insurance, and everything else that you need. Thank you very much.